Society at Stanford Law School. We're very excited to be hosting this event, Understanding the Impeachment Process. For those of you who don't know us, ACS is the nation's leading progressive legal organization. It was founded on the principle that the law should be a force to improve the lives of all people. I also want to thank the Stanford Center on the Legal Profession and the Stanford Constitutional Law Center for hosting this event with us. We have an incredible panel for you today, and I would like to introduce them now. To your far right is Professor Jack Rakove. He's a professor of history, American studies, political science, and by courtesy law at Stanford. He is the author of 6 books, including the Pulitzer Prize-winning Original Meanings, Politics and Ideas in the Making of the Constitution. He's written numerous articles on the history of impeachment and was a witness to the House Judiciary Hearings on the background and the history of impeachment in 1998. In the middle is Professor Deborah Brody. She's Professor of Law and Director of the Stanford Center on the Legal Profession. She's authored 30 books in the fields of professional responsibility, leadership, gender, law, and public policy, and is the nation's most frequently cited scholar on legal ethics. She worked as counsel to the House Judiciary Committee during the impeachment proceedings against President Bill Clinton and authored a 94-page committee report on the constitutional grounds for presidential impeachment. Finally, Professor David Sklansky. He's Professor of Law and faculty co-director of the Stanford Criminal Justice Center. He teaches and writes on criminal law, criminal procedure, and evidence. He's also won the campus-wide teaching award at every school he's been on the faculty. And he's written widely about the impeachment against President Trump and has been interviewed on the subject as a legal expert in recent weeks by the media. Without further ado, please join me in welcoming our panel.
Well, since I was trained as an early American historian, that means one of my customary roles in life is always to be the leadoff batter, since I can take the long view from the 17th and 18th century. I think the panel generally agrees we should try to get as many points out there as quickly as we can. We're sure there'll be a large number of questions you guys will want to raise. So I think we'll try to be as provocative as we can at the beginning, and then we'll just see where the conversation carries us thereafter. So I think there are basically kind of 5 points I want to make over, I guess, the next 10 minutes or so. The first is a kind of preliminary remark. There's been a lot of discussion, really, since January 20th, 2017, as to at what point will we be in a constitutional crisis. There's a discussion if the nation were to resort to the impeachment clause, or if alternatively, what I used to think would be equally probable, the 25th Amendment, and questions of president disability were to come into play. Would that launch us into a genuine constitutional crisis? My own position on this is, it would not. It's hard to say you have a constitutional crisis when you can resort to mechanisms that are in the Constitution itself, which do suggest some measure of foresight as to steps the nation might want to take under certain circumstances. To my way of thinking, the real constitutional crisis of the Trump presidency is the Trump presidency. And the reason for that is, they have ample reason to believe that the president is mentally, psychologically, intellectually, temperamentally incompetent to exercise the office. If you guys are at all acquainted with the idea of the unitary theory of the presidency, which says the executive power shall be vested in the President of the United States. In the end, the president is the sole decision maker, and you have to assume in that case, if he's the sole decision maker, you want to have a high degree of confidence in his or her capacity to do things in an intelligent way. What's been confirmed most recently, again, just over the weekend, is Trump is actually utterly incompetent to discharge the office, to which he was elected. So that's my first response to resort to impeachment. Certainly politically, it would be highly charged and a delicate moment. It would be a highly dynamic moment in American politics. But the real crisis that we're engaged in is the Trump presidency itself. Second point, when I think about this historically, and I think the point I try to make when I testified actually with Deborah's support and assistance back in 1998, is to ask the question, if you want to think about where impeachment fits in the overall constitutional scheme, it's important to know that of all the institutions that the framers of the Constitution created, the most difficult one, and the one whose operations were most difficult to anticipate, was the presidency. A lot of times, I think, particularly when you're in a law school crowd, people say, well, no, the judiciary was, in the power of judicial review, that's kind of the great anomaly and innovation in American constitutionalism. But if you situate yourself in the 18th century, you ask the question which the framers faced, what would be the character of a national Republican, lowercase r, national Republican executive? There was no model ready to hand for how you would constitute executive power in the kind of national republic the framers were creating. And one consequence of that is the debates on the presidency went on episodically, really throughout the course of the Constitutional Convention. The delegates made a lot of progress at the very beginning to agree that the executive power should be placed in a single individual, and he should possess the veto. That's a non-trivial addition to the realm of executive power. But in the weeks and months that followed, the framers looped around and around on the question of how would the president be elected and with what powers substantively would he be vested. They were still working on this less than 10 days before the convention adjourned. In fact, the last critical vote on the impeachment power took place on September 8th. The convention adjourned on September 17th. And because this is the case, when you think about the executive powers as it was constituted in 1787, I think it's important to see that there's what I like to think of as a kind of matrix of relations among key facets of the presidency. How long will the president serve? Will the president be, should the president serve a single term, or should he be eligible for re-election? If you're not certain how the mechanism of presidential selection will work, would there not ramp up the need to have something like the impeachment clause present available in the Constitution in case the whole system functioned in ways that one had not anticipated? I'd like to stress, I think the more confidence one has, I want to come back to this point, I think the more confidence one has in the process of presidential selection or election, the less need there should be in general to rely on the impeachment clause. That's to say, I think my position would have been closer to Speaker Pelosi's original position, which is in the end, if you want to defend democracy, which I think is the challenge we now all face, the best way to do that is to rely on the electoral process itself. That would be the one best mechanism available to deliver the verdict or the judgment you want to have rendered. I've changed my mind on this a bit since, but I think when we think about impeachment, it's important to know that it was hard to discuss it just on its own, for its own purposes and uses. That it was always tied to a matrix of very difficult decisions that preoccupied and perplexed the phrases, or to use Madison's phrase, the presidency was the product of tedious or reiterated discussions that recurred throughout the convention. That's my second point. The third point, kind of the deep original meaning point, is that in its final form, it's important for everyone to know that once the framers were working on the final version that gave us the electoral college system, it's essentially a set of debates that took place between September 4th and September 8th, 1787. And it's essentially the so-called Committee on Postponed Parts came up with the whole model of the electoral college and how electors would be portioned among the states and so on. On the very last day of that week of debates, the framers looked at the impeachment clause, and two of the three non-signers of the Constitution, there are three delegates present who did not sign the Constitution in the end: George Mason, Elbridge Gerry, and Edmund Randolph. All three, well, two of them became anti-federalists. Randolph's a more complicated case. So Mason raises the question when he wants to bring the impeachment clause back up under the clause as it came from I believe the so-called Committee on Postponed Parts, kind of a great name for a committee, chaired by David Brearley. The two bases for impeachment were treason and bribery, which could be thought of as being separate, or they could also be regarded as being likely to be linked. That's to say, bribery would be a great source of committing treason. So it's easy to see how those two things would conflate or converge. So Mason pops up and says he thinks that the constitutional basis for impeachment does not go as broadly as it should go. So he suggests maladministration. He says, there are many instances of misbehavior that treason and bribery will not capture. So he goes, in effect, to what might be regarded as the opposite end of the spectrum. Treason and bribery are very specific. The Constitution itself defines what treason is, and it's not hard to figure out what bribery is, at least in many cases. Maladministration, if you think about it, really lies at the opposite end of the spectrum. Maladministration, in a certain sense, could be regarded as a very subjective, impressionistic, open-ended, open-textured kind of clause, where kind of any kind of collapse in the adequate performance of executive duty would provide a basis for impeachment. If you wanted to create a president there's going to be as much as possible constitutionally and politically independent of the legislative branch, maladministration seemed to be just too open-ended, too open-ended a term to be effective. Maladministration really would leave would really leave the presidency subject to let's say an excess of legislative or congressional discretion. So James Madison's response to this was to come up with high crimes and misdemeanors. And as soon as he did that, I think there was an intervening remark by Elbridge Gerry seconding Mason's motion. Madison says, maladministration is just too open-ended a term. But I say high crimes and misdemeanors, which was probably capacious enough to capture, the larger realm of misadventures that George Mason was getting at, but was not so capacious to be open-ended. And without further debate, with I think the three middle states, I think Pennsylvania, Delaware, and New Jersey voted no on this, but so 8 states to 3, the convention approved the high crimes and misdemeanors. It's a phrase that goes back in English history, I believe, to the 14th century. When we were today, it sounds like high crimes and misdemeanors, jaywalking, not coming to full stop when you're turning right. So it is to be understood as essentially as a political term, a kind of great offense against the system of government. Now, misdemeanors throws us off because of its contemporary usage. It's my third point. My fourth point is, as I said before, is that I think in the abstract, I think the more confidence we have that the election system works, the less reliance we ought to place on impeachment. I mean, I think we ought to know historically, and I think being in a panel of lawyers, it's a good place to make this point, is there is no doctrine of impeachment. I mean, we've had, depending on how you count them, episodes involving, Clinton, Nixon, Andrew Johnson, and arguably Andrew Jackson. Each of those episodes was idiosyncratic. Each one does not build upon the other. Every Congress has to kind of sense decide for itself exactly how impeachment should be applied in some given set of circumstances. So because that's the case, every time an episode comes up, we get nervous, and I think rightly so, as to exactly how the political system ought to operate in terms of deciding. I mean, I would have said, opposite of Bill Clinton, that if the Republicans could impeach Bill Clinton, you could impeach almost any president for anything. I mean, I think the Republicans in 1998-99 lowered the impeachment bar as far as it could possibly go, and for details, I mean, Deborah could talk about this at greater length than I could. But after 1998-99, in a certain sense, that's I won't say almost any presidential action, but anything you found truly controversial would become actionable. But it's important to know historically that impeachment in English-British history, was a kind of curiously political practice. It had flourished in the 17th century during the period of great opposition between Parliament and the Stuart monarchy. It essentially had run out of gas I think the last serious British impeachment was 1715. At least for the next 70 years, although it was revived at the time of the writing the Constitution and the impeachment of Warren Hastings, who was the Governor General of India and who became kind of a bête noire for Edmund Burke, who was a member of Parliament. Burke launched a long-running impeachment battle against Hastings. You have to think Hastings is occupying a truly anomalous position in government. He's representing the British Empire in distant India. It's such a kind of anomalous fact situation. It's hard to generalize from that. So, on that basis, I would have said, impeachment in general, somewhat abstractly, impeachment, although it's in the Constitution and certainly obviously constitutional, is a remedy we ought to avoid whenever possible. And again, as I said previously, if we want to vindicate democracy, elections are the best way to do that. But in this case, I think two conditions weigh decisively in the opposite direction. One, if to go on the current fact situation, when the act you're objecting to involved the corruption of the election process itself, which of course was also true of Richard Nixon, if you go back to the obstruction of justice and and the Watergate burglary, to rely on the election process itself when the president seems intent on corrupting its operation, would itself, provide, a reasonably strong vindication for resorting to impeachment. And secondly, I think as Speaker Pelosi has said, wholly independent of the sensible political calculations, which I think were restraining her previously, the actions of, the whole Ukrainian business, assuming that it's certainly not the sole base of impeachment, but at the moment it's the dominant one. It is such an overt act. It is such an overt defiance of constitutional norms, particularly, given if you go back to the timing, which is the Washington Post, I think, is just updated within the last day or two. Go back to the fact that, the seemingly critical phone call between Trump and Zelensky took place the day after Mueller's appearance in Congress, which most Democrats regarded as a sense of disappointment. On the very next day, Trump is reverting to the same form of behavior for which he'd been widely criticized, going back to the summer of 2016. So I think Pelosi's position is one in the end that I would accept. That the offense is so overt, it would be constitutionally irresponsible for the House of Representatives not to pursue impeachment, even if you're not wholly certain what the political results will be. That wraps it up for me.
So this event for me prompted a short walk down memory lane, and there's not much to recall fondly about the experience. But since analogies to the Clinton proceedings are so frequently in the news, and many of you don't have much memory of it, I'm going to fill in a few details, take questions later if anyone wants more context. As a preliminary matter, I should just say a word about how I got my ringside seat, given that I am not a con law expert and I had absolutely no political connections. In the summer before the 1998 hearings in the House of Representatives, I got a call out of the blue from a prominent Washington, D.C. lawyer whose name I didn't recognize, who asked if he could come to Palo Alto and take me to lunch. Well, it seemed like kind of a lot of time and money for not such great food, so I suggested, maybe we could just chat by phone. No, he said it was kind of sensitive. Well, fine, I thought. It's midsummer, and I had lots of lunchtime availability. So he came, and it turned out he wanted me to take a leave and work as counsel to the House Democrats on the Judiciary Committee. And in answer to the why me question, he said, well, the House leadership thought that they were going to need some expertise in gender and ethics, where President Clinton seemed somewhat challenged. And I just happened to have that combination. So I went to Washington and talked to the top Democrats, including the then minority leader, Richard Gephardt, who asked why I might be interested in the job. And since ethics is my day job, I defaulted to an honest answer, nothing about the country and civic responsibility. I said, well, I think I will learn new things. And that turned out to be the right reason to take the job, since my presence did not do much to advance gender or ethics sensitivity. But I did learn a lot, not what I expected to learn. So I'll share with you a couple of insights that are relevant to the current moment. First, I did know that, as con law experts often point out, impeachment is preeminently a political process. But I was not prepared for just how political it would be in an age of polarization and partisanship. Everything was skewed by ideological concerns. The Republicans controlled the House, and therefore the House budget, and therefore the budget for the impeachment inquiry, which meant that Republicans got twice the number of lawyers on their staff and immediate access to support staff, offices, related resources. Those of us working for the Democrats got none of that, and we spent the first month really without an office, sitting on the floor outside the secure facility where evidence relevant to the impeachment was kept. One night when we were working late and a member of the House Judiciary came by to review some of the evidence, he asked what we were doing sitting on the floor, doing our emails on cell phones. And the chief counsel responded dryly, "I wish you guys would win some elections so we could get some chairs." And it was like that for the whole proceedings. The Republican chair of the committee had no commitment to due process. We, the Democratic staff, got almost no notice of anything, committee hearings, no chance to challenge biased procedural rulings. We actually learned about decisions for timing and hearings along with the rest of the country by watching the television news. And although there was a pretense of interest in what the standard for impeachment was, the high crimes and misdemeanors, what did it actually mean, almost no one from either party really thought that mattered. One of my roles for the committee was to assemble the con law experts to testify the standards. Jack was one of my picks. But actually, sad to say, no one was paying any attention to what they said. Many Republicans didn't come at all, and those who did sort of multitasked while they were there. And their concern was all about spin and not about substance. The chair made clear his disdain for the whole hearing process. He told one journalist that the committee had had such a parade of professors that members should get academic credit for attending. And he frequently shared his definition of an intellectual, someone educated beyond his intelligence. The second thing I learned about Washington was the truth of the famous quip that it's a city of fake sincerity and real hypocrisy. And the examples of hypocrisy were endless. Take, for example, just the behavior that had unleashed the chain of events leading to impeachment. Some of you may recall that there was a claim in a civil sexual harassment case that then Governor Bill Clinton had propositioned a state employee for oral sex. There was no claim of retaliation or damages, and the suit was financed by conservative political opponents whose real agenda was not support for victims of sexual exploitation, but of unearthing other evidence of Clinton's extramarital affairs, including one that he was then recently had conducted with a 22-year-old White House intern, Monica Lewinsky. Clinton ran some polls about America's likely reaction to disclosure of the affair, and that led him to the expedient decision to deny it under oath, even couldn't recall being alone with her. This turned out to be a mistake when Lewinsky was subpoenaed and forced to reveal that she had a dress with some semen still on it. Clinton then responded with a somewhat implausible claim that the sex he'd been asked about was not really sex because it was oral sex. And the alone stuff, well, there were people around the outside of his office. So the Republicans were off to the races with that. So this was all about his obstruction of justice in a civil lawsuit that was politically motivated, and suddenly you had all these conservative Republicans waxing eloquent in defense of vulnerable women like Paula Jones and Monica Lewinsky, and talking even about the sanctity of marriage, until it was revealed that some of them, too, had had affairs, some with government staff, and the House Speaker actually had to resign when his behavior was revealed. So, hypocrisy everywhere. The Republicans, of course, as you will remember, had the votes in the House to impeach, but not in the Senate to convict. So their position in bringing the impeachment proceedings had much more to do with their political self-interest than the substance of the charges or the good of the country. And that was pretty much true as far as I could see of everyone involved in the process. Everyone was thinking about their own interests, very little about the country's. On the day the House vote was taken and our legal team was mercifully disbanded, the chief counsel called us all together for a little brief gesture of appreciation for our services, which had been pretty much 24/7 for 4 solid months. He gave all of us some token inappropriate gifts. The paralegal got House of Representatives cufflinks suitable for a shirt he would never wear or own. And then the chief counsel said, tellingly, "I just want to thank you guys for making me look good." And that really was how he defined our jobs. He wanted recognition from everyone, the White House, the Democrats, the television viewing public, whatever the consequences for anyone else. And I think that was pretty much true of most of the politicians involved in the process. And that tells us something about the final takeaway. The politicians then and now are concerned with what's going to make them look good. And it's often pointed out that the Clinton impeachment vote backfired on the Republicans. They lost in the next election. Clinton left office with what was then the highest ever approval rating for a departing president. And not only was there political backlash from an obviously politically motivated vendetta, it just turned out that most Americans cared a lot more about the state of economy, which was good under Clinton, than his sex life, which 2/3 of them thought didn't have anything to do with his performance as president. So that leads us to the question, well, what do the politicians care about today? And I think what they care about today is what's going to make them look good with the voters that are crucial for them. So what would it take to convince enough voters that Trump is unfit for office, such that, and so unfit that the Republicans in the Senate would vote to remove him? And on that point, I'm sad to say that recent research I've done for a book on character, including the character of politicians, suggests that it would take a lot. Integrity is something that voters support in principle, but they rarely prioritize in practice. Polls find, for example, that 95% of Americans think that a president's character is important. 2/3 agree that it's very important. Yet only 1/3 thinks it's more important than policies. And the 2016 presidential campaign was a textbook illustration of those views. Polls during the campaign indicated that 2/3 of Americans didn't think that Trump had strong moral character, and 62 million voters voted for him anyway. Trump is an extreme but not an isolated case. And really since the mid-20th century, it's been far more common for the losing presidential candidate to be evaluated better on honesty and integrity than the winning candidate. So, is Ukraine enough to shift the narrative? Well, we know it's moved the needle. Yesterday's New York Times reported that a compilation of the latest public opinion polls showed that about 49% supports impeachment, 43% opposes it. It's not clear how many people in these polls know that impeachment is just an indictment, not removal from office. So the findings are a little fuzzy. But what we do know is that all but a few Republican senators are still holding fast to Trump's coattails because only 17% of Republicans want Trump impeached, and presumably a fewer number removed from office. At this moment, they don't seem, the Republican politicians, all that disturbed by any of the things that Jack mentioned that I agree they should be disturbed about. It could be that if something more is unearthed, if he openly defied subpoenas by the court and the Supreme Court, backed that up, that might be a bridge too far for some Republicans. But I'm not making any predictions. I, like most Americans, vastly underestimated Trump's appeal as a presidential candidate, and I'm not going to replicate that error again. So I'll let all of you speculate further in the question and answer period, or maybe David will take a shot at it.
I'm not going to take a shot at that. I'm not a constitutional lawyer, and I haven't worked on an impeachment inquiry, and I'm not a historian. The only reason that I've wound up talking to reporters a fair bit over the last couple weeks about impeachment is that people, mostly the president and his supporters, keep analogizing to the criminal process, which I do know something about, and reporters call me to ask about it. So, for example, the president tweeted on September 29th, "Like every American, I deserve to meet my accuser, especially when this accuser, the so-called whistleblower, represented a perfect conversation with a foreign leader in a totally inaccurate and fraudulent way." Yesterday, the president retweeted the following: "Serial killers get more due process than the Democrats are giving the president of the United States." And then this morning, Ken Starr, who was the special prosecutor in the Whitewater investigation, was on Fox News. He's a contributor to Fox News, which means I gather he's paid about $50,000 a year to come on as an expert. And here's I didn't see Fox News has like a thing. You don't have to actually watch it. You can go online and they will tell you what happened. So here's what they say happened. The secrecy exercise by House Democrats in their display of raw power and their impeachment push goes against everything the U.S. government stands for and should concern all Americans, said former Special Prosecutor Ken Starr on America's Newsroom Monday.
There it is. Real hypocrisy right there.
He called the process profoundly wrong and said the American public should be disturbed by the lack of protocol and due process. Let the public assess the evidence, he said. The House is given the sole power to impeach, not a committee and not the Speaker. I think this is something that every American should be concerned about, that the Speaker is not calling for a vote. It tells me that this is a very unorthodox, untraditional procedure, and they should stop it. Starr claimed American society has always been supportive of public trials in the interest of total transparency and called for an open process to help maintain the credibility of the government. Secrecy is bad unless there's a compelling need for secrecy, he said. We believe fervently in public trials. Now, why is that? Because we want to be able to see. The juries need to be able to see and hear the witnesses. We need, as the American people, to be able not just to hear or read a transcript eventually. We need to hear and see because that's to do with credibility, Starr said. There's this fear of transparency. I'm not going to get into motivations, he said. I know that Democrats have the raw power to do exactly what they're doing, but they don't have the moral right to do what they're doing. What they're doing is constitutionally wrong. It's a raw power play that appears to be unprecedented in American history. So that's all wrong. So first of all, as Jack explained, I mean, pretty much anything that the House does to structure its inquiries can be unprecedented because we just don't have that many times when we've had an impeachment inquiry. And one of the times when Andrew Johnson was impeached, there was virtually no process before the vote in the House of Representatives. So almost anything they do is going to be unprecedented. The Constitution itself says very little about how the process has to work. It says that conviction in the Senate requires a two-thirds vote, and the House has the sole power to impeach. And beyond that, the House has to figure out how to structure its inquiry. I've had to explain repeatedly to reporters over the last few weeks that it's not true that in America everybody gets a right to confront their accuser. We have a confrontation right in the Constitution. We have a right to public trials, but those are rights that attach to criminal trials. They don't attach to other proceedings. They don't attach to criminal investigations. Ken Starr was the special prosecutor in the Whitewater case, so he knows that when you're investigating a crime, when you're deciding whether to file a charge, you don't do that publicly generally. It's true that we've had 2 impeachment inquiries of presidents where that was done publicly. But it's not generally true that you don't have a, and even in you'll learn if you take evidence law that even in a criminal trial, you don't get to confront everybody who accused you. You get to confront the people on whose testimony the prosecution is relying. So if we model the impeachment inquiry on a criminal proceeding, that would mean that if there's an impeachment and then there's a trial in the House, the Senate should not consider testimony from people who don't testify in a proceeding in which the president's lawyers get to confront them and cross-examine them. That's what it would mean. It doesn't have any implications for how the House structures its inquiry at this point. It's true that the Nixon and Clinton impeachment inquiries in the House did involve public hearings and did provide opportunity for the president's lawyers to confront at least some of the witnesses. So the House needs some reason to conduct these hearings in secrecy if they're going to do it legitimately. The reason the Democrats have given for conducting these hearings in secret is first that these are hearings before the Intelligence Committee and the Foreign Affairs Committee, and they involve confidential matters having to do with foreign affairs and intelligence that witnesses need to be able to speak freely about, and the committee then needs to think about what needs to be redacted before it's released. That's the first reason. The second reason is that the President of the United States has publicly called for unmasking the whistleblower and retaliating against that person, and has suggested that we might take guidance from the fact that spies used to be executed. So those strike me as good reasons to hold an investigation in secret. I mean, I was a prosecutor. If I was investigating somebody who publicly suggested that people who had informed against him should be killed, I would question those people in private. So anyway, that's all I have to say. Maybe we should open it up for questions at this point.
Well, thank you to each of you for those remarks. We now have time for Q&A. We have two microphones here. We'll trade off whoever's standing at the microphones. We just ask that students get first priority in asking questions, and please actually make your questions questions.
Hi, thank you guys for coming. I had one question, I guess a two-part question. Quickly, I think I'd heard Adam Schiff say a third reason why they didn't want to have public testimony so that witnesses couldn't coordinate responses, and I was wondering if that was also something that was taken into consideration. I think that's a quick answer. My second question was more related to contemporary definition of misdemeanor versus the sort of back in the 17th century and previous centuries before that. I'm wondering if you could potentially provide like some sort of analogy for what, you know, a high crime and misdemeanor was meant at the time of the Constitution, because I still have, you know, very limited understanding of what that would actually mean. I think a lot of people generally know there's sort of the idea of it's whatever the Senate says it is or whatever that joke is, but like maybe something practically what people were thinking at that time.
Well, it's true that Schiff. I don't know. I don't know. I didn't know that Schiff had said that that was one of the reasons. But if that was cited as one of the reasons, that wouldn't be a novel argument for secrecy. I mean, before a felony indictment in a criminal case, the process takes place in front of a grand jury, which meets in secret. The defense attorneys aren't allowed in. Lawyers for the witnesses aren't allowed in. And one reason for that's often been cited for holding those proceedings in secret is to prevent witnesses from coordinating their stories. I'm not very moved by that argument. That doesn't strike me as a very strong reason to hold the proceedings in secret. And I think if that were the only reason to hold the proceedings in secret, I would oppose holding them in secret.
Yeah, well, this is often the case with historical analogs. My answer is going to be somewhat complicated. If you look on the English British side, as I said, the phrase, I haven't checked this recently, I think the phrase itself goes back to the 14th century. The heyday of impeachment was the 17th century, and the political logic of impeachment was, which is, contrary to what we think is our scheme of government. Trump wants to deny this is, the king is the sovereign. You cannot make the king subject to law in the ordinary sense of the term. So impeachment was a device used to get all those figures around the king who were implementing his policies, including leading ministers. It's clear in that case that, there is a kind of deep political set of priorities, associations, agenda underlying impeachments. When you get the early 18th century, until you get to Hastings on the English side, the last impeachment in Britain is something about, and I'm a little weak on the diplomatic history, it's something involving something called the Partition Treaty. I think it relates to that. I'm not even sure what it relates to, but it has to do with a treaty that was controversial where the opponents of the treaty wanted to impeach the negotiators, which I think they did in the House of Commons, and the House of Lords didn't even bother to hold a trial. When you get to Warren Hastings, it's because there are substantial charges of the kind of gross misuse of power by the East India Company, which is in effect a surrogate imperial government operating in India. So I'm not, that's kind of fleshing it out. I think there's also something else I need to go back to. I think there were impeachments were done and kind of incidentally in the American colonies in the 18th century. Peter Hofer has a book on this. I think, again, and Deborah's going to see if I'm right or wrong about this, but anyhow, I think, again, you have the same problem you had in 17th century England. It's hard to impeach it's that the governor is, politically independent. His authority depends upon the crown. Hard to get at him directly. I think the key point is just that, I think the device had a somewhat, clouded background, for the framers. But I think precisely because, there's so many open questions about how the presidency would operate. There is one last point that deserves mention, though. Does anybody here know what the Treaty of Dover was? 1670? This is a true Trivial Pursuits question. It's when Louis XIV, Louis XIV, buys off Charles II. And in effect, Charles agrees to make British foreign policy subordinate to the needs of the Crown of France. In exchange, I think the French gave him a mistress who, rose to some. This is what we're back in the game. So, gave him a gorgeous French mistress, and Charles got an independent grant of funds from the French crown, which he needed because Parliament was riding his case. It's actually directly related to I've done work on the emoluments issue. A recherché word in the 18th century, but in our time, but actually fairly commonplace term. It's the same set of notions applies. It goes back to the treason and bribery. When the framers thought about treason and bribery as part of the impeachment clause, they actually had specific historic example in mind. It was about at that point it was about 120 years old, give or take. But the Treaty of Dover was a well-known event. Becomes well known in the 18th century. It was a secret treaty. It wasn't publicized, but eventually news about it got out. So those are all kinds of the kind of contextual ways to think about how they might have thought about the issue.
I'll give you just one more. I pulled out, this is a great book, Impeachment Handbook, Charles Black, updated by Philip Bobbitt just this past year. And this was obviously a major discussion during the Clinton proceedings because a lot of people thought that lying about sex in a civil trial did not rise to the level of high crimes and misdemeanors, whatever the Republicans said about perjury. And what he says here is, in the constitutional sense, it ought to include offenses which are seriously threaten the order of political society as to make dangerous the continuation in power of the perpetrator. So he says you have to read misdemeanors in the context of high crimes and treason, so that it should refer to offenses that aren't those two, but are of significant and similar weight. And I think that was pretty much, as I vaguely recall it, the consensus of the constitutional experts who testified, which, as I related earlier, had almost no bearing, as far as I could tell, on the actual votes cast. But there's a long hearing report, which I labored mightily over, and it would give me great pleasure if someone would actually read it now, because we went to a lot of trouble to try to define this for the American people, and nobody cared much then. I kind of doubt they care much now either, but yeah. Anyway, to you.
Thank you all for being here. So given that the Constitution leads this process up to the House, what are your opinions on what process rights or rules of evidence the House should opt into to make this feel legitimate to the public?
I think that the House should stick with the procedures that were followed in the Nixon and Trump inquiries, unless there's a reason.
Trump.
I'm sorry, the Trump and the Nixon and Clinton inquiries, unless there's a reason to diverge from. So I think that the hearings before the Intelligence Committee should be public, unless there's a reason not to make them public. I think if there are witnesses that the minority wants to call, I think that the committee should call those witnesses unless there's a reason not to. So I think in general, since we had one nice thing about the position we're in right now is that the two most recent impeachment inquiries were of presidents from opposite parties. So if there's something that was done in both of those instances, I think in general would be a good idea to follow that practice unless there's a reason to depart from it. And I think the major departure so far has been holding these hearings in secret. I do think that there's a reason to hold them in secret. I'm not that swayed by the business about you want to make sure witnesses don't coordinate their stories, but I think it's fairly extraordinary to have the president suggesting that his accuser should be unmasked and killed. And I just, that seems to me a good reason to conduct the hearings behind closed doors.
I just want to say one thing about the value of transparency. It can cut both ways. And it's so rich to hear Starr waxing eloquent about process and transparency, because if there was ever an investigation that totally lacked it, it was his. And I wrote a whole little article in the Stanford Law Review to sort of expiate after this experience, in which I detail all the ways in which the Trump investigation violated everything: ethics, conflicts of interest, transparency, etc. But the one thing that they did want transparency on was everything that was on the tapes between Monica Lewinsky and Linda Tripp, her confidant, because the American people needed to know everything about Clinton's sex life. So, there we were, with whiteout, literally, the day before these things are released in the Starr report, arguing about taking out expletives when they were leaving in everything that had absolutely no bearing on anything that was remotely related to high crimes or misdemeanors. It was all about Clinton's sex life. And, so that's what the American people got. The Starr report sold off the bookshelves, and just endless details of stuff that nobody should have to read about, no family member. It was just a kind of a travesty. So I think, when we talk about the right to know, let's put it in a political context. And certainly if we're going to make analogies to the way things were done during the Clinton hearings, it wasn't a model of that. It appeared that there was a lot of transparency about some stuff, but things like Starr's threats to Lewinsky to prosecute her family for tax evasion if she didn't cooperate, that didn't come out. So evaluate it all with a grain of salt and try to come up, I think, with the kind of procedure that you would want if you were in that situation. kind of Rawlsian approach. Envision yourself being in those circumstances or someone close to you. What kind of process would strike you as fair? And try to leave the political considerations to one side.
It's also worth recalling, I mean, having lived through Watergate and remembering it fairly vividly, though not down to, every day an event, but it's worth recalling that there were two sets of hearings. I mean, there was the Senate Select Committee, which was chaired by, Senator Sam Ervin from North Carolina, in some ways a great constitutionalist, but also, a bona fide Dixie segregationist. Included also, Howard Baker, who famously kept asking, what did the president know and when did he know it? Now, a fair number, if I remember correctly, correct me if I'm wrong, but it seems to be a fair number of criminal charges involving people around Nixon came out, originated in the Senate Select Committee hearing, so that people like Haldeman, Ehrlichman, Attorney General John Mitchell, perhaps a worthy predecessor of Bill Barr, in some respects, faced criminal charges. And then once enough information was generated around the president, at that point, the House Judiciary Committee came into being with its responsibility to look specifically at impeachment. But there was a process, and I think, if I remember correctly, I think the Senate committees began in the, sometime in the spring of 1973, maybe March or April. I have to go back and check. And, the work of the House Judiciary Committee really took off pretty much, I think, in the summer of 1974. That's a much more prolonged process, and it's clear, the situation we're dealing now is much more volatile and has a high rate of velocity.
So I think each of you have mentioned something about how there really isn't a precedent or a process. If you were to kind of envision the ideal process and maybe two components of that process that you haven't seen historically or that you would want somebody to implement, what would those two components of process be?
I guess, I think I made this point originally. I mean, to my way of thinking, I think you still have the idiosyncratic problem. It's hard to anticipate the particular fact circumstances that will that would govern any impeachment. But I suppose maybe just, I think to generalize in a fairly obvious way from, I think, what Dave was saying, if you think of the House as the grand jury and the Senate as the trial, as the trial body, maybe that's a useful way to try to simplify how we think about the whole procedure.
I wouldn't model it on the grand jury. I mean, I have mixed feelings about the grand jury in the criminal process. So I think, and it's not because I think the grand jury provides too much protection to potential defendants. The grand jury is an institution that was designed originally to stand between the prosecutor and potential criminal defendants, but it hasn't functioned that way for well over a century. I wouldn't want to import it into the impeachment context. I think there is a benefit to public hearings if you can do it without endangering people's lives. The question of if I could invent something from scratch is a really good one, and I need to think about it. I have to say I am inclined to want staff more involved because I find myself when I watch hearings getting frustrated at what I seems to be clumsy questioning by elected representatives of witnesses. So, but I want to think about that more.
Yeah, I mean, I will revert to my earlier statement, try to envision a process that you would think would be fair for yourself or a loved one and try to strip as much of the politics away. I think the other thing that's likely to be missing, though, in this process is compliance with subpoenas. And, Clinton, for whatever his other ethical challenges, did comply. And he testified under oath, both in the Paula Jones case and before Starr. So there was, and all the evidence was turned over. And now, we got a president who's really thumbing his nose at the whole process on the grounds that it's politically motivated. Well, welcome to the world of impeachment. It is a political process, and to say you're not going to comply with it because it is what it is just so fundamentally antithetical to the rule of law. But that's obviously not something that carries a lot of weight in this administration. So there we are, and I think, one question is whether the Democrats faced with that intransigence are just going to go with what they got, or whether they're going to try to fight it out in the courts in a way that would be timely. And I don't think there's a whole lot of appetite at the Supreme Court for entering the fray expeditiously here. So that would drag things out if they decide to really try to get those subpoenas enforced.
So I did think of something. I know we have another question, so I want to get to it, but I'll mention this because I think it might be a good subject for a student note if any of you are interested. If I was redesigning procedures, I would bolster the protections for whistleblowers. I think it's been one of the many unanticipated twists of this story that whistleblowers turn out to be such a critical part of what's happened. And I think that the way this has played out has highlighted gaps in the protections that we provide to whistleblowers. So I would want to.
Yeah, I'm all for that. I don't know if some of you saw the comic headline by Andy Borowitz, who writes political satire for The New Yorker. Trump bans all whistles in administration.
Do we have time for one more question? Yeah. Okay. Yeah.
One thing that's really striking about the Nixon impeachment inquiry is how many major Republican figures were close to Nixon and stuck by him. So Bush Sr. was head of RNC, Bork, I think, became AG. At a certain point, do you think there'll be any political ramifications for the Republican Party or long-term political ramifications? And is there any incentive for Republicans to write rank with Trump, or do you think that there exists a political process?
Well, remember what did, oust Nixon from office? It was Republicans who told him, you've got to resign. If you push this to a vote, you will not survive. So, it was the Republicans who did that. It was a much, for all its other failures, it was a less partisan time. And when Republicans got the tapes, that's the ultimate irony of Nixon. He was brought down by what he was hoping would establish his legacy of greatness. When it came out that there were actually conversations in which he had orchestrated the obstruction of justice, that was the final nail in the coffin. And it was enough to get enough Republicans to force him out. And it's just hard to see what that would be for this president, as long as the public opinion polls suggest that the Republican base and sort of those halfway in the Republican camp are just not gonna lessen their loyalty.
Being a historian, I believe the first rule of behavior is predict nothing. You have to take each day as it comes and to prepare to be surprised. But at this point, I say Republicans will be with Trump until they no longer have to be with Trump. I mean, I think it's not hard to imagine a scenario where if the Republicans realize they're risking losing control of the Senate, which would, as well as the presidency, and I think a lot of them are giving up on the House already. So, so I think at that point, people like to say, 3 weeks in politics is an eternity. 3 months is, gets you into the world to come or whatever. So I think you just have to be aware of contingency. Let me make one big historian's point on this. It's something I did discuss this a few weeks ago at a symposium in Madison, Wisconsin. If you think about as I spend a lot of time doing, because I spend most of my waking hours not these days when I'm obsessed, but usually in the 18th century. But there's no bigger difference in the norms of the political world that the framers inhabited and the ones in the norms we inhabit today, is that in the 18th century, very few people thought of politics as a profession. And very few people thought that political behavior would be dominated by the desire of the incumbents to be reelected. Madison, I spent a lot of time thinking about Madison. Madison hoped that creating a national government would help to foster the idea of politics as a career, that you'd find more people like himself who really saw it as, something you could, pursue more or less full time. But the norm remained, and in fact, this is the behavior corresponded to this, that, each Congress would in a sense have its own, would be its own entity. That you'd have high rates of turnover. In fact, the mean term of service in the House of Representatives for the first century of the Constitution was 3 years, meaning that the great bulk of members serve, one term or two. There are very few two-term senators in the 19th century. They start to emerge, only after the Civil War. Today, of course, the obsession to be reelected has become the dominant, that's the independent variable that seems to drive most political behavior, particularly in Congress. So that's an enormous disparity. But on the other hand, if that variable comes into play, I mean, if Republicans in the Senate, in particular, find themselves in danger, enough votes might flip. It also might be the case that whether or not you convict Trump, because in the end there is an election coming up. Let's say you don't get a strong party line vote. So let's say it depends upon him. He has to get to 34 in the Senate to block conviction. If you have 60-some senators from both parties, that would be a non-trivial fact going into the presidential election too.
Well, and I think there's some hope on the part of the Democrats that there's still gold in their hills, and if they keep digging long enough, there'll be other whistleblowers. Stuff will leak. Hope springs eternal.
In the human breast.
We done? Well, thank you all. This was great.